Welcome and thank you for joining Seyfarth's webinar, Terminations and Settlements after Reuter, How to Avoid Paying Thrice. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A feature located on the right side of your WebEx window. We'll do our best to get to everyone's questions. However, if your question is not answered, our presenters will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Following the webinar, there will be a 15-minute office hours. Actually, I'm sorry, there will not be a 15-minute office hours. You can submit questions in the Q&A function of the chat, which your attendees will answer or follow up with you after the webinar. Copies of the webinar recording and materials will be distributed to attendees in the days following the presentation. At this time, I'd like to turn the program over to Barry Miller.
Thank you, Christian, and thank you to all of you who are joining us for our third in a trilogy of webinars about the Supreme Judicial Court's recent ruling in Reuter versus City of Methuen, which has some really tectonic impacts on wage and hour law in Massachusetts. I'm Barry Miller. I'm joined by Allison Silvera and Tim Buckley. All of us are wage and hour lawyers in Seyfarth's Boston office. You get both the still pictures here and the video pictures as well. We can go on to the next slide. That provides a little bit of an overview of what we're going to talk to you about today. Our prior webinars, which are recorded and available for anyone who missed them, provided a digest of Reuter, what the court held, and some of its implications in broad terms. Our second installment also focused in particular on incentive and commission plans, which have highlighted importance after Reuter. And for this third and final webinar, we are focusing on some of the day-to-day issues that are going to recur in the lives of human resources and payroll professionals after Reuter. And we've divided those really into two categories. The first is the set of requirements in the Massachusetts Wage Act that pertain to payments to terminated employees, folks who have either resigned or been fired, and are due wages potentially earlier than their typical pay date. And so Tim is going to talk us through some of the logistics of that. And the second major category of issues that is going to recur in our lives after Reuter is a set of complications about trying to settle any sort of dispute pertaining to what an employee may be owed. And the usual game of walking on eggshells has got a little bit more eggshelly after Reuter, because simple mistakes and very minor mistakes in some ways, including paying someone as little as 1 day late, can have outsized ramifications. And we'll talk through the details of that a little bit further as we go on. The last point that I will make before turning this over to Tim is that while this is new stuff and the Reuter decision is very recent, none of what you're about to hear is theoretical. We are not prognosticating that plaintiffs' employment lawyers may start using this as a lever to make employers' lives more difficult. We are telling you that they are doing this. And that started within days, maybe within hours after the Reuter ruling. We do see folks acting on behalf of employees trying to assert these multiple damage claims under what would have been sort of humdrum scenarios before Reuter. So with that, I will turn it over to Tim.
Thanks, Barry. And can we go on to the next slide, please? So as Barry noted, I'm going to be focusing on considerations when faced with an employee's resignation or termination. And the first place that we really want to start is with the statute itself. So the question, as the slide states, is what does the Wage Act require when dealing with resignations or terminations? And as you'll note on the slide, the Wage Act for resignations provides that an employee shall be paid in full on the following regular payday, or in the absence of a regular payday, on the following Saturday. So that's the context of resignations. The rules, as I'm sure many of you are familiar with, are stricter when it comes to terminations. And the Wage Act requires that an employee shall be paid in full on the day of his discharge. And the day of the discharge is where we get into a lot of difficulties with the Wage Act. But it's not limited to just but the potential difficulties are not limited to just terminations in the day of discharge. They can also arise when we're dealing with resignations as well. And while resignations, we might think of them as the typical resignation being something that someone gives 2 weeks notice, so you have ample time to prepare for a final day and therefore calculate the appropriate pay for the final day. It's not always the case. And an employee can provide a week or even a day's notice, or they can just announce that they're not going to come back the next day. And that's going to trigger the Wage Act requirements, not to pay them on the following regular payday. So we can go to the next slide. When we look at the language in the Wage Act for terminated employees, the language requires, as I said, final payments be made day of. And it's critical, as Barry alluded to in the introduction, that these payments are made on the day of termination. As you'll see on the slide, it becomes somewhat of a common practice to give discharged employees the options to choose between whether to receive payment in the form of a check at the time of termination, or a direct deposit on the next regular payday, or potentially even an electronic transfer that might not hit the employee's account until the next day. We should not be giving employees that choice. As Barry again alluded to in the introduction, there's already litigation seeking damages under Reuter where an employee chooses to be paid via direct deposit as opposed to receiving a paycheck on their final day. And unfortunately, under the strict interpretation of the Wage Act, which the SJC has made abundantly clear that it is employing, it's going to be a technical violation of the Wage Act, and all of the penalties associated with the Wage Act will potentially follow. Now, the key here is the funds must be available to the employee on the day of termination. If they're not, it's a violation of the Wage Act, again, subject to treble damages. And again, these types of violations, these have played out in court before. There was a case back in 2015 in the federal district court where an employee was terminated. All of the appropriate calculations were made for the employee's final wages, and an electronic payment was initiated on the employee's final day. However, in that case, the monies did not hit the employee's account until the following day. And when that happened, the court held that it was a technical violation of the Wage Act. Now, back then, before Reuter, the damages were significantly lower, but now with Reuter, it's gonna be treated as if that employee was a much more egregious penalty, or no, sorry, a much more egregious violation of the Wage Act. But it is that fine of a line that we're dealing with now. Could we go to the next slide, please? So we do want to be mildly optimistic on this webinar. And so we're not just going to focus on all the terrible things that can happen, but we're going to focus a bit on what we can actually do to try to better position ourselves here. And we've identified some measures that we can take. The first measure that we have up here is to assess and, where necessary, improve your payroll processes. And there's, employers' payroll processes are going to vary significantly. It's going to be based upon the business. It's going to be based upon the employees at issue. So there's really no one-size-fits-all solution here. But what is important is that employers take a look at their own specific payroll processes and identify potential points of failure, or not even failure, because it's really failure or delay that can lead to an employee's payroll being, an employee's payroll being slightly delayed. Now, some of the things that just come up at the top of the head for improving payroll processes, likely want to minimize reliance on things such as paper slips for timekeeping, or relying upon employees to submit their own hours, or having elongated approval processes. Because all of these things, either combined or individually, can lead to points of delay that will lead to slowdowns in the payroll processing, which, when you're looking to calculate an employee's final wages due, can become problematic. The next thing that we want to look at are making sure that our accruals for vacation, sick time, and then bonuses and other compensation that needs to be paid in the final paycheck, that these amounts are consistently updated. And really, given the strictness of the landscape in which we're operating, we want to have the accrual balances as up-to-date as possible. We want to have bonus information as up-to-date as possible. And if we're dealing with, say, commissioned employees, and we want to be dealing with having the commission information as up-to-date as possible. Because in the context of a termination or even a limited notice resignation, these balances are going to need to be calculated and paid out in very short order. So we want to have consistent accruals and consistent up-to-date information for these types of compensation. The final point that we have here is dealing with ensuring a clean communication process for resigning employees. And this is not just like who an employee has to denote, or sorry, who the employee needs to inform of their resignation. This is more on the back end. This is more after an employee informs their manager or HR personnel that they're resigning, that person knows who they need to contact in order to make payments right away. So if an employee informs their manager that they're resigning and their last day is going to be in 2 weeks, that manager should be able to identify every person who they're going to need to contact to inform the business of the resignation, so that the final calculations can be made and that the payment can be effectuated in time. All right, we go to the next slide, please. So, when we're dealing again with terminations, one of the interesting things that the Reuter decision noted was that, well, the SJC did at least acknowledge that in the context of terminations, that the Wage Act's requirements are very strict. It's day of. But the SJC seems to hold the view that because the decision to terminate is within the employer's control, that strict language of the statute makes sense, and that the employer thus controls when to terminate an employee and thus controls when final payments need to be due. The SJC went out of their way to note that suspension in lieu of immediate termination might be a viable option for employers in order to comply with the Wage Act. So what they noted was, in effect, that an employer does not have all of their ducks in a row to terminate an employee and effectuate final payment for that employee, the employer could consider suspending the employee for a short period of time in lieu of immediate termination, so that they can do the work necessary in order to calculate the final payments and timely make those payments under the Wage Act. So this is another, say, option in the arsenal when dealing with employees who might warrant termination. Employers should consider whether or not a suspension is going to be appropriate. Now, suspensions may not work in all circumstances. For one, with unionized employers, sure, anyone with unionized workforce here doesn't need me to mention it, but you have to look at the collective bargaining agreements and applicable labor laws before looking at suspensions or terminations. But also, there are other circumstances where it might not work as well. For instance, with regulated financial entities, can't just or may not be able to simply suspend someone who they've uncovered has been committing fraud. So the SJC has highlighted suspensions as being a possibility here, and it's something that we should consider moving forward, particularly if we're not sure we'll be able to make final payments before the day of discharge. And next slide, please. Okay. Now, a couple of other things we want to talk about when dealing with terminations. And this is a bit more of the mechanical aspects of it as opposed to the decision between suspension and termination. The first thing we really want to highlight is, no matter what it is, you want to have a mechanism or mechanisms in place for making immediate payments. Out-of-cycle payroll checks might be a way to do it if you have the time to order one and have it cut before the day of discharge. However, there are some other options that might be available as well. Another consideration might be having dedicated funds for final payments. For instance, if you have a retail establishment there's an immediate termination of a store level employee, one option would be to simply go to the front cash register and pay the person out for all amounts that are due. Another option might be, if it's a store or even a location level, is you might have a dedicated account which always contains a sufficient amount of money to be able to cut a check for final pay for a terminated employee or a limited notice resignation employee. So these are just some practical considerations that you want to keep in mind for if you only have a very limited amount of time to get a final payment out, how are we going to do it? A couple of other things to quickly note. If we're making these types of payments, we want to ensure that the payouts are documented, particularly these slightly more ad hoc fashions, paying someone out of a cash register. At minimum, we think we're going to want the precise amount, the date, and a signed acknowledgement from the employee that they received this amount on this date. A couple of other points to note: if there are amounts that are, if the amounts that are due are not known with precision, you might consider making a buffer payment. Now, as a simple example, if it's unclear whether or not an employee is owed 1 week of vacation or 2 weeks of vacation, you might consider including 2 weeks of vacation in their final pay at termination. Because while it's ultimately going to be a business decision and cost-benefit analysis, you might be paying 1 week extra vacation and avoiding a potential headache down the road of a lawsuit where they could recover 3 times that amount and attorney's fees and the cost of defense as well. Final point that we just want to note here is if payroll function is outsourced, whether it's through a third-party payroll service or a PEO, you want to suggest connecting with the PEO or whoever the third-party vendor is to ensure that they're able to readily make these payments. And if not, you might consider training someone in-house to make the day of calculations and make the day of payments, because the fact of the matter is it's not going to matter whether it's the third party's fault or the employer's fault. The employer is going to be on the hook. And then with that, I think we can go to the next slide. And I'm happy to report I have the CLE code, which is SS9127. And again, that's SS9127. And with that, I can turn it over to Allison to talk about settlements.
Thanks, Tim. So turning to the topic of settlements, when Reuter first came down, one of our initial concerns was whether, now that we know treble damages and attorney's fees is a statutory right, can employers continue to settle cases for anything less than treble damages and obtain a valid and enforceable release? And the reason for this concern is that the Wage Act explicitly prohibits employers from entering into special contracts with employees that would alter the Act's requirements. The SJC has repeatedly recognized that the Wage Act's special contract prohibition is specifically intended to ensure an employee has statutory protections over their rights to wages. In 2012, in Crocker v. Townsend Oil, the SJC considered whether a settlement agreement that purported to release wage claims in Massachusetts was a prohibited special contract because prompt payment of wages is guaranteed by the Wage Act. And in reaching their decision, the SJC balanced the plaintiff's claim that the Wage Act's protections cannot be unknowingly frittered away through a settlement agreement with the public policy in favor of enforcing general releases. And the SJC was addressing a concern that parties would be unable to settle employment claims by compromising or foregoing a Wage Act claim where that is the intention of all the parties. So it concluded, even despite the special contract prohibition, that general releases are enforceable, but only if such an agreement is stated in clear and unmistakable terms. In other words, according to the SJC, the release must be plainly worded and understandable to the average individual, and it must specifically refer to the rights and claims under the Wage Act that the employee is waiving. So for the last decade since Crocker, the general practice has been that any settlement agreement that purports to release wage claims in Massachusetts specifically enumerates General Laws Chapter 149 in the release. For example, employee waives all claims or rights arising under the Massachusetts Payment of Wages laws, which includes the Wage Act and the Minimum Fair Wage Law. Prior to Reuter, we'd already seen some courts in Massachusetts, especially district courts, sort of taking the position that this type of language was too broad and needed to be more specific. And next slide, Christian. And now with Reuter, I think we kind of feel that in full effect. And so because Reuter made clear that employees are statutorily entitled to treble damages, we, under Crocker, employers should still be able to obtain a valid release of wage-related claims, including for late payment of claims, but the release itself likely needs to be even more explicit than what had been the general practice in Massachusetts. And what we mean by that is that if you're looking towards entering into a settlement agreement that's going to cover wage-related claims, you want to ensure that the release provision of that settlement calls out as precisely as possible the wage-related claims being released. And so that means you might enumerate everything from back pay to front pay, overtime, bonuses, commissions, all types of whatever the claims are, all the way down to off the clock, any salary related claims, meal and rest, meal break claims. And depending on the type of work that your employees perform, you may also want to enumerate sort of industry specific. So it's really a question of thinking through specifically for this employee who is going to be entering into a release, or for your company in general. Do you want to include things as specific as tips and tip sharing, on-call pay, waiting time, reporting pay? So the more explicit you get, obviously it's a catch-22, because the more explicit you get, the increased risk that you'll be deemed to have waived anything that's not specifically enumerated, even with general catch-all language. But under Crocker, and now especially under Reuter, you really want to put the time into thinking through these types of callouts and being as comprehensive as possible, because the generalized language that had become the practice after Crocker faces a pretty big risk of being deemed insufficient to constitute a knowing release by the employee, given this treble damages and statutory fees, and just where we see the SJC going and its current makeup. And no one wants to end up in a situation where you reach a settlement and think that you have settled a claim and then get sued for a claim you thought was released. So in addition to specifically enumerating claims, you also want to explicitly reference even the subsections of Chapter 149 that the released claims are covering, and also specifically include in the release language that the release encompasses statutory or treble damages. Next slide, Christian. So there are two we've bucketed settlement scenarios into two types of claim scenarios. The first where there's clear liability, and the second where an employee brings a claim but it's defensible, meaning maybe it's a late payment but only because of an alleged misclassification, and there's a defense to the misclassification claim. There's no longer, as we all know, an incentive under Reuter to make a payment up front if you discover a payroll error, if before there's any litigation, and it's no longer because it's no longer a valid defense to the claim to promptly make the single payment of wages. But it may still be the right thing to do, and I think a lot of employers have questions about, if it's the right thing to do, what do I do? And there are three approaches to that. One, it's a business decision across the board what your level of risk tolerance is. You could make no payment and wait and see what happens and what the employees what happens, what employee makes a claim about. You could pay immediately when you discover there's been an error, pay the single wage amounts, and then wait and see, and not proactively pay the additional statutory damages. But if you make that decision, there's a risk that if you do have to pay the statutory damages down the road, that it's going to include interest, and then it's going to include attorney's fees. Or you could pay the treble damages, which some employers are doing, and make clear that if you make a payment on treble damages, making clear that it's intended to cover the wages and the statutory damages as a result of the late payment. If you opt for the first scenario, where you're going to just wait and see, and you're not going to make a payment right away, you're going to see what happens, and then an employee comes to you and says, makes a late payment claim that there is in fact a late payment claim, we would recommend in those situations structuring a release so that it's 1/3 for the lost wages. It's very explicit. 1/3 for the lost wages subject to W-2, 2/3 for the statutory damages in the form of a 1099, and do it quickly so that you're minimizing any attorney's fees. If you opt for the second scenario where there's clear liability and you made that single damages payment right away, then you can enter into a settlement agreement at that point, and it can be entirely for statutory damages. So you could 1099 the entire amount as statutory damages, because you've already paid, and you'd make clear in the release and in the settlement agreement that you've already paid the single damages, and have the employee acknowledge that as well up front. And if you opt for number 3, where you pay the full amount of the treble damages up front, there should be no claim, because at that point you have fully paid what the employee would be entitled to for statutory damage under the Wage Act, and there's no damages owing. Kristen, the next slide. So in the other scenario, so now you're looking at, you have an employment claim and there is a defense to liability. Those cases are still, in our view, still, if there's a genuine and good faith dispute as to whether the employees due wages at all, the amount of a settlement, those are still settleable, and the amount of a settlement is still purely amount of compromise. You would make clear, our recommendation is making clear in a settlement agreement where you're going to settle that type of claim. For example, the example I gave before about misclassification. If you're going to settle that type of claim, you would want to make clear in a whereas clause up front that the employee has made the claim and that the employer denies and continues to deny the allegations, and that the settlement is the product of, without conceding liability or truth of the allegations, which the employer expressly denies, that the settlement is a product of compromise. And in those instances, because of the requirement of the treble damages, we would still recommend that 1/3 of the amount that's going to the employee be attributed to wages and the remaining 2/3 be 1099, just so the breakdown is clear on that you're covering both the single damages and the statutory damages, even if the amount that you're paying is not tied to either, your damages calculation or the plaintiff's, but is simply the product of compromise. Barry, I think I'm going to turn it over to you for wrapping it all up.
Sure, leave me with the hard stuff. Up to this point, we've been focusing on these issues that will recur on a day-to-day basis and that pertain mostly to individual employees. But as class action lawyers, we see bigger problems that this set of consideration poses. Christian, let's take a look at the next slide. These are just a couple of examples of one of these late payment situations gone nuclear. And again, there's nothing about this that's theoretical, abstract, or potential. This is all very real. One potential example is an employer who has a data breach, is hacked, is subject to ransomware or something like that, and is physically unable to execute on payroll, the date that wages are due. I've had several such cases, and even before Reuter, plaintiffs' lawyers were very quick to seek very massive damages awards based on late payments. In other words, if your payroll for a given run was $1 million, they would come looking for $3 million, $2 million just in penalties for late wages. And that's going to be a much more difficult case to defend after Reuter. Prior to Reuter, we won those cases outright. Now, most of the defenses that we had applied in those cases have been taken away. And so when you have a problem like this, when your payroll is delayed, for example, you have essentially the same options that have been discussed earlier in this webinar, but on a much larger scale. Do you go ahead and pay everyone 3 times their wages for the date that you missed payroll? Do you undertake to enter into settlement agreements with some of these employees to provide for a resolution that calls for less than 3 times the amount? Or do you just sit back and wait to get sued and then pay treble damages once issue is joined and the parameters of the dispute are clear? None of those are good options. And when something like that happens, the employer is going to be faced with the choice of the least worst option. And there are no across the board rules for what that may be. But one thing we do know is that's going to pose a very difficult choice. Another version of this that recurs regularly in my practice is when an employer calls me up and says, we found an error. We've been paying people the wrong amount for some period of time. And you're not talking about one person, you're talking about, for example, failure to make an adjustment when minimum wage goes up a little bit, or failure to include some sort of differential in someone's overtime rate for purposes of FLSA overtime. And you've discovered this error. Well, pre-Reuter, our solution to that was very straightforward, and it boiled down to pay people as quickly as possible before you get sued and are on the hook for treble damages. Now that card has been pulled from the deck. It's simply not an option. And so the employer is going, again, to have to make a hard decision about whether to try to unwind that liability by making proactive payments or just sit back and wait to get sued for the full amount. Again, no good answer there. So let's go to the next slide. We've put some thought into how is all of this going to develop. It's all very new, and what are we going to be looking at 6 months, a year, 5 years from now? The forecast is a little gloomy, as this slide points out. There's no indication of any relief for employers coming, and in fact, it looks like it's going to get worse before it gets better. There's a statute that is pending before the Massachusetts legislature that has very broad support and no visible opposition, which is a form of wage theft legislation. We have prepared an alert on that, which is broadly available, but one of the things it does is make Private Attorney General Act claims available. It expands the circumstances in which you may be liable for other entities' wage violations. It expands the remedies that the Attorney General has to prosecute wage violations. And so in combination, that legislation is probably as difficult for employers as Reuter. We have heard some rumblings among our constituents, employers, about legislation to respond to Reuter, because Reuter is very much an interpretation of the statute by the Supreme Judicial Court. And if the General Court, the legislature, wanted to soften the impact of Reuter and provide a cushion for employers to respond, it could very easily do that. There are a number of ideas out there for amending the statute to make it much less harsh. And there was an editorial a couple of weeks ago in Mass Lawyers Weekly, as the slide references, on behalf of the editorial board, which happens to include former Justice of the Supreme Judicial Court, Bob Cordy, saying all of this has gone too far, and we need to think about some way to pare back the Wage Act and make it much less draconian than it appears to become, or to be becoming. That has yet to crystallize into any sort of legislative action at this point. There's no bills pending or any organized push in the legislature to do anything like that. So those of you who are frustrated by this scenario, we have the what can you do slide, or the what can you do bullet. Again, all of these are less than satisfactory options. None of them is going to solve the problem. But if there are employer representatives out there who are looking to potentially make an impact here, it is a political issue, a legislative issue primarily up to this point. And so the solutions are political in nature. And the one thing that you can do to avoid some of the calamity that we've talked about here is to make sure that your compliance measures around wage and hour law are fully up to date. And there is no argument that compliance with Massachusetts wage and hour law is easy. It's not. One thing that will help is a fairly comprehensive guide that we publish every few years called Massachusetts Peculiarities. We've just published the most recent version of that. Folks who have not received an announcement of it can certainly contact us and reach out to us at any time for any questions you may have about Massachusetts wage and hour law. And I believe that is the last substantive slide. Thank you all for joining us, and good luck out there.